Hey everybody, NCWQ here. Well, I've never really done this before, but we're going to go over something. The ICC put out a article today, and it was their briefing. And they put out the situation of Palestine. ICC pretrial chamber 1 rejects state of Israel's challenge to jurisdiction and issues warrants of arrest for Benjamin Netanyahu and Yoav Gallant. And it says today on 21st December 2024, pretrial chamber 1 of the International Criminal Court in its composition for the situation in the state of Palestine unanimously issued 2 decisions rejecting the challenges by the state of Israel brought under Articles 18 and 19 of the Rome Statute. It also issued warrants of arrest for Mr. Benjamin Netanyahu and Mr. Yoav Gallant. Decision on the request by the State of Israel. The Chamber ruled on 2 requests submitted by Israel on 26 September 2024. In the first request, Israel challenged the court's jurisdiction over the situation of the state of Palestine in general and over Israel's nationals, more specifically on the basis of Articles 19 of the statute. In the second request, Israel requested that the chamber order the prosecution to provide a new notification of the initiation of the investigation to its authorities under Article 18 of the statute. Israel also requested the chamber to halt any proceedings before the court in the relevant situation, including the consideration of the applications for warrants of arrest for Mr. Benjamin Netanyahu and Mr. Yoav Gallant submitted by the prosecution on 20th May 2024. As to the first challenge, the chamber noted that the acceptance by Israel of the court's jurisdiction is not required, as the court can exercise its jurisdiction on the basis of territorial jurisdiction of Palestine, as determined by pretrial chamber 1 in the previous composition. Furthermore, the chamber considered that pursuant to Article 19 of the statute, states are not entitled to challenge the court's jurisdiction under Article 19 prior to the issuance of an warrant of arrest. Thus, Israel's challenge is premature. Thus, is without prejudice to any future possible challenge to the court's jurisdiction and/or admissibility of any particular case. And this is the decision on Israel's challenge to the jurisdiction of the court pursuant to Article 19 of the Rome Statute. And that's what this is right here. So, as a state that goes through all of this, office and and the registry, and the pretrial chamber, and this is the procedural history, and it says on January 1st, 2015, the state of Palestine accepted the jurisdiction of the court from 13 June 2014. And it says onwards by way of Article 12 declaration, the next day on 2nd January 2015, Palestine acceded to the Rome Statute. Okay, on 22nd May 2018, Palestine referred the situation to the state of Palestine to the prosecution pursuant to Articles 13 and 14 of the statute, following which the presidency referred the situation in the state of Palestine to the chamber. On 5th February 2021, pretrial chamber 1 and in different composition by majority rendered the decision on the prosecution request pursuant to Article 19 for the ruling on the court's territorial jurisdiction in Palestine, in which it found that Palestine is a state party to the Rome Statute and that, in consequence, Palestine qualifies as the state territory of which the conduct in question occurred for the purposes of Article 12 of the statute, and that the court's territorial jurisdiction and the situation extends to the territories occupied by Israel since 1967, namely Gaza and the West Bank, including East Jerusalem. On March 3, 2021, the prosecutor announced the opening of the investigation with respect to alleged crimes within the jurisdiction of the court committed in the situation since 13 June 2014. On 17th November 2023, the prosecution received further referrals pursuant to the Articles 13 and 14 of the statute from 5 state parties. On 14 January 2024, 2 more state parties submitted such a referral to the prosecution. On 20 May 2024, the prosecutor publicly announced that he will be filing applications for warrants of arrest against Mr. Benjamin Netanyahu and Mr. Yoav Gallant. On 20 September 2024, the registry transmitted the challenge into the case record. Israel requests the chamber to declare with immediate effect that the investigation of the prosecutor in the cases of Mr. Netanyahu and Mr. Gallant and the proceedings before this chamber under Article 58 of the statute are to be suspended until the court has given its ruling on this challenge to the jurisdiction and to determine that the application concerning Mr. Netanyahu and Mr. Gallant and any investigative action on the same jurisdictional basis are not within the court's jurisdiction, and to dismiss the prosecution's application for arrest warrants for Mr. Netanyahu and Mr. Gallant. On 23 September 2024, the prosecution submitted its response to the challenge. The response. On 7 October 2024, the registry transmitted into the case record a request by Israel for leave to reply to the response, the leave to reply request. Determination of the chamber. 10. With regard to the leave, excuse me. With regard to the leave to reply request, the chamber considers that the challenge and the response are significantly clear and that the issues identified by Israel for further submissions could either have been reasonably anticipated or do not relate to the matters that the chamber requires further information on. The leave to reply request is therefore rejected. Consideration of challenge. Israel challenges the court's jurisdiction regarding the prosecution's applications for warrants of arrest against Mr. Netanyahu and Mr. Gallant and any other investigative action on the same jurisdictional basis. Israel argues that Palestine does not possess the competence required under international law to be able to delegate territorial jurisdiction to the court. In terms of standing, Israel refers to the chamber's holding in 2021 that issues of territorial jurisdiction may be raised by interested states based on Article 19 of the statute. Israel submits that it is a state from which acceptance of jurisdiction is required under Article 12 of the statute, even if there is another state which has delegated jurisdiction to the court for the same situation. This is incorrect as a matter of law. In the matter under consideration, the acceptance by Israel of the court's jurisdiction is not required, as the court can exercise its jurisdiction on the basis of the territorial jurisdiction of Palestine. As soon as there is one jurisdictional basis pursuant to Article 12A or B of the statute, there is no need for additional one. Israel also argues that its claim that Palestine is not a state or on the territory of which the alleged conduct occurred is in itself sufficient to make it the sole state whose acceptance of jurisdiction is required. It points out it would be problematic to deny standing on the basis that a state needs to be establish the merits of jurisdictional challenge as a prerequisite to its standing to make it. Israel submits that all that it is required for it to have standing under Article 19 of the statute is that it claims it is prima facie tenable. Israel further alleges that it has an immediate right to challenge jurisdiction under Article 19 given the current stage of the proceedings, and that it is in fact under an obligation to do so now pursuant to Article 19 of the statute. According to Israel, its obligation to act without further delay is triggered by the fact that it now knows, based on public statement of the prosecutor and on the basis of requests for assistance it received from the court, that Israeli nationals are the subject of applications for arrest warrants in relation to acts that allegedly took place on the territory of Gaza. First, the chamber rejects Israel's argument that merely because it claims that Palestine could not have delegated jurisdiction to the court, the chamber would have to ignore its previous decision rendered in its different composition, which has become res judicata. Indeed, there is a fundamental difference between granting a state standing on a presumptive validity of its claim to have jurisdiction over a situation or a case and granting it standing on the basis of an argument, which was already ruled upon, that its particular state party does not have jurisdiction. Well, I'm going to state it right now. There are 124 countries that are part of this court, and Israel is not one of them, neither is the United States, China, or Russia. In any event, Israel's standing is not an issue in this instant, as Israel clearly would have to have standing to bring a challenge as a state of nationality under Juncto Article of the Statute of the Chamber decides to issue any warrants of arrest for Israeli nationals. The issue before the Chamber is whether Israel is entitled or indeed obliged to bring such a challenge before the Chamber has ruled on the prosecution's application for warrants of arrest. The Chamber notes that states are not entitled under the statute to challenge jurisdiction of the court on the basis of Article 19 prior to the issuance of arrest warrant or a summons. Indeed, the prosecution typically conducts the entire application process under Article 58 of statute ex parte. Statutes, therefore, only become aware of the existence of the proceedings after the court has ruled on the application when the arrest warrant or summons is notified to them or made public. The wording of Article 19 of the statute makes it clear that states may only challenge the court's jurisdiction in relation to a particular case, i.e., after the relevant pretrial chamber ruled that there are reasonable grounds to believe that a person has committed a crime within the jurisdiction of the court and issued a warrant of arrest or a summons to ensure that the person's appearance before the court. The Chamber wishes to reassure Israel that it will not be stopped on the basis of Article 19 of the statute from bringing a jurisdictional challenge because of the public statements made by the prosecutor or the request for assistance it has received from the court in relation to the investigation. Israel have full opportunity to challenge the court's jurisdiction and or admissibility of any particular case if and when the Chamber issues any arrest warrants or summonses against its nationals. The Chamber hereby, for the above reasons, rejects Israel's request for leave to reply and rejects Israel's challenge to the jurisdiction of the court pursuant to Articles 19 of the statute as premature. The Chamber also rejected requests under Article 18 of the statute. The Chamber recalled that the prosecution notified Israel of the initiation of investigation in 2021. At that time, despite a clarification request by the prosecution, Israel elected not to pursue any requests for deferral of the investigation. Further, the Chamber considered that the parameters of the investigation in the situation have remained the same, and as a consequence, no new notification of the State of Israel was required. In light of this, the judges found that there was no reason to halt the considerations of the applications for the warrants of arrest. So, let's go to the next one. So this was the pretrial chamber 1. And it says on 1st January 2015, the state of Palestine accepted the jurisdiction of the court from 13 June 2014 onwards by way of article, declaration, and so forth. And it's the same thing as the first one. It says the same thing as the first one here. We're going to get into the determination. The court observes that Israel submitted the request for chamber, request for extension of the page limit, and the related request for leave to reply to the prosecution's opposition to such an extension. These requests have become moot with the submission of the request. As to leave to reply request, the Chamber considers that the request and response are clear and that no further submissions are required to the Chamber to consider the matter. reconsiderations of the merits of the request, based on the submissions of Israel and the prosecution, as well as the material before the chamber, and the chamber understands that on 9th March 2021, the prosecution notified all state parties and other states with jurisdiction, including Israel, pursuant to Article 18 of the statute, that it had initiated an investigation in the situation. On 8th April 2021, Israel sent a letter to the prosecution indicating its firm view that the court manifestly lacks jurisdiction over the situation and submitting that Israel's robust legal system has and will continue to examine and investigate rigorously all allegations of misconduct or crimes, and to hold to account those persons within a jurisdiction found to be responsible. The 8th April 2021 letter. On 9th April 2021, with reference to 8 April 2021 letter, the prosecution sent a letter to Israel, inter alia, requesting clarification whether it was the government of Israel's intention to trigger the applications of Article 18 of the statute, and if so, the specific domestic proceedings to which any request for deferral under Article 18 might relate. The clarification request. On April 2021, the legal advisor of Embassy of Israel to the Netherlands sent an email to the prosecution conveying that Israel maintains its principal position that the court manifestly lacks jurisdiction over the situation, maintains its grave reservations regarding the handling of the situation by the OTP, and will continue to examine and investigate rigorously all allegations of misconduct or crimes, regardless of their source, and to hold to account those responsible. The 26th April 2021 letter. On 1 May 2024, Israel sent a letter to the prosecution requesting to defer any investigation it may be conducting in relation to alleged criminal acts attributed to Israeli nationals or others within Israel's jurisdiction in favor of Israel's process for review, examination, investigation, and proceedings under its national legal system. And that was the 1 May 2024 letter. On 7 May 2024, the prosecution responded to the 1 May 2024 letter by stating that Israel has no standing now under the statute to make such application, given that it had expressly declined to make an application for deferral of the investigation within the prescribed time limit. In its request, Israel inter alia submits that in its 8 April 2021 letter, it asserted that its notification was not sufficiently specific, and that it reiterated this assertion in its 26 April 2021 letter. Israel does not indicate what its consequence of its contention would be, but to the extent it intends to argue that the notification was deficient and as such cannot have served as a notification pursuant to Article 18 of the statute. This argument fails. Based on the material before it, the Chamber considered that the prosecution complied with its statutory obligations when it provided Israel and other states with the notification. As explained by the Appeals Chamber, a notification under Article 18 of the statute shall contain information relevant for the purposes of Article 18, Paragraph 2, the statute, namely the general parameters of the situation in sufficient detail with respect to the groups or categories of individuals in relation to the relevant criminality, including the patterns and forms of criminality that the prosecution intends to investigate. The Chamber specifically notes that the notification included the types of alleged crimes, potential alleged perpetrators, the starting point of the relevant time frame, as well as a reference to further relevant information, including the summary of the prosecution's preliminary examination findings. Therefore, the notification was sufficiently specific. Based on the material before it, The Chamber notes that despite the prosecution's clarification request, Israel did not proceed to request a deferral under Article 18 of the Statute of 2021. Instead, it merely repeated its previous arguments on the court's alleged lack of jurisdiction and stated that it continued investigating all relevant crimes. In regard, the Chamber recalls that for a state to be successful in seeking a deferral, it is neither enough for it to make a blanket statement that the court lacks jurisdiction, nor to simply assert that it is investigating and prosecuting crimes which may constitute crimes under Article 5 of the statute, and that relate to notification under Article 18 of the statute. Therefore, Israel's 8 April 2021 letter and 26 April 2021 letter did not constitute a deferral request under Article 18 of the statute. The Chamber further notes that pursuant to Article 18 of the statute, a state may inform the court that it is investigating or has investigated its nationals or others within its jurisdiction with respect to criminal acts which may constitute crimes referred to in Article 5 and which relate to information provided in the notification to states provided by the prosecution under Article 18 of the statute, within a period of 1 month of receipt of said notification. In light of this, the statutory time limit had passed in April 2021 without Israel having requested a deferral under Article 18 of the statute. In any case, filing the request at this point in time, namely after the prosecution announced it had filed application of warrants of arrest and 3 years after the passing of the statutory time limit, appears to go against the very object and purpose of the statutory complementary framework. The purpose of Article 18 proceedings is to allow for complementary related admissibility challenges to be brought to the initial stage of the investigation and not at a point in time when the investigation has substantially advanced, where a state is given the opportunity to assert its right to exercise jurisdiction, but it has declined, failed, or neglected to do so, the investigation may proceed. 1 second. I need water. The Chamber is also not persuaded by Israel's submission that a new situation has arisen or an investigation with new defining parameters has been taken place since 7th October 2023. The Chamber notes that the notification indicated that the investigation concerned alleged crimes in the context of international and armed conflict, Israel's alleged conduct in the context of an occupation and a non-international armed conflict between Hamas and Israel, and the applications for warrants of arrest, as also explained by the prosecutor in his public statement at the time of filing the applications. The prosecution alleges conduct committed in the context of the same type of armed conflicts concerning the same territories with the same alleged parties to these conflicts. Therefore, no substantial changes has occurred to the parameters of the investigations into the situation. The Chamber notes that Israel's position would effectively mean that the prosecution's investigation into every situation would be limited to the incidents and crimes addressed during the preliminary examination and described in the Article 18 notification. Such interpretation has already been rejected by the appeals chamber. There was and is therefore no obligation for the prosecution to provide new notification to the relevant states pursuant to Article 18 of the statute, and as such to provide a new 1-month timeline for requests for deferral. The Chamber's conclusion do not impact in any way the ability of the states, including Israel, to raise issues of admissibility for cases brought by the prosecution to the context of the investigation. Indeed, Article 19 of the state allows a state which has jurisdiction over a case to challenge the admissibility of such a case on the ground that it is investigating or prosecuting or has investigated or prosecuted the respective case. The Chamber hereby, for the above reasons, declares Israel's request for an extension of the page limit and its request for leave to reply to the prosecution's response to the page limit request moot, rejects Israel's request for leave to reply, and rejects Israel's request for an order to the prosecution to give an Article 18 notice and staying proceedings pending such notice. Done in English, a French translation will follow. An English version remains authoritative. So, anyways, the chamber issued warrants of arrest for two individuals, Mr. Benjamin Netanyahu and Mr. Yoav Gallant, for crimes against humanity and war crimes committed from at least 8 October 2023 until at least 20 May 2024, the day the prosecution filed the application for warrants of arrest. The arrest warrants are classified as secret in order to protect witnesses and to safeguard the conduct of the investigations. However, the Chamber decided to release the information below since conduct similar to that addressed in the warrant of arrest appears to be ongoing. Moreover, the Chamber considers it to be in the interest of victims and their families that they are made aware the warrants exist. At the outset, the Chamber considered that the alleged conduct of Mr. Netanyahu and Mr. Gallant falls within the jurisdiction of the court. The Chamber recalled that in previous composition, it already decided that the court's jurisdiction in the situation extended to Gaza and the West Bank, including East Jerusalem. Furthermore, the Chamber declined to use its discretionary proprio motu powers to determine the admissibility of the two cases at this stage. This is without prejudice to any determination as to the jurisdiction and admissibility of the cases at a later stage. With regard to the crimes, the Chamber found reasonable grounds to believe that Mr. Netanyahu, born on 21st October 1949, Prime Minister of Israel at the time of the relevant conduct, and Mr. Gallant, born on 8th November 1958, Minister of Defense of Israel at the time of the alleged conduct, each bear criminal responsibility for the following crimes as co-perpetrators of committing the acts jointly with others, the war crime of starvation as a method of warfare, the crimes against humanity for murder, persecution, and other inhumane acts. I'll say something about that in a minute. The Chamber also found reasonable grounds to believe that Mr. Netanyahu and Mr. Gallant each bear criminal responsibility as civilian superiors for the war crime of intentionally directing an attack against civilian population. So, the alleged crimes, the Chamber found reasonable grounds to believe that during the relevant time, international humanitarian law related to international armed conflict between Israel and Palestine applied. This is because they are two high contracting parties to the 1949 Geneva Conventions and because Israel occupies at least part of Palestine. The Chamber also found that law related to non-international and armed conflict applied to the fighting between Israel and Hamas. The Chamber found that the alleged conduct of Mr. Netanyahu and Mr. Gallant concerned the activities of the Israeli government bodies and the armed forces against civilian population in Palestine, more specifically civilians in Gaza. It therefore concerned the relationship between the two parties to an international armed conflict, as well as the relationship between an occupying power and a population in occupied territory. For these reasons, with regards to war crimes, the Chamber found it appropriate to issue arrest warrants pursuant to the law of international armed conflict. The Chamber also found that the alleged crimes against humanity were part of the widespread and systematic attack against the civilian population of Gaza. And I'm going to stop right here and I'm going to ask about where are the arrest warrants for Hamas? Where's the arrest warrants for them for the attack that they did against the people of Israel? Okay, so I'm just saying that out there. I mean, asking for a friend. Okay. Chamber considered that there are reasonable grounds to believe that both individuals intentionally and knowingly deprived the civilian population of Gaza with objects indispensable to their survival, including food, water, medicine, and medical supplies. Well, I've heard that over 200 trucks go in a day. So I've been doing some research on that. I'd like to know why I've been reading that over 200 trucks go in per day, and that's because Israel sends them in. So I'll just keep reading. As well as food and electricity from at least 8 October 2023 to 20 May 2024. Well, let me see here. Maybe because Hamas has been keeping that food from getting to the people. So, do some research and you might find that out. This finding is based on the role of Mr. Netanyahu and Mr. Gallant in impeding humanitarian aid in violation of international humanitarian law and their failure to facilitate relief by all means at its disposal, which is BS. The Chamber found that their conduct led to the disruption of the ability of humanitarian organizations to provide food and other essential goods to the population in need in Gaza. So I'm going to stop right here and I'm going to look at something real quick. How many how many aid trucks go into Gaza every day? I want to look this up. Okay. See, they're being ransacked. So if you look here, they're being ransacked as they're going in. So, yeah, they're going in. They're just being ransacked. 109 trucks going in by UNRWA, okay, World Food Programs, crossing in. 97 trucks lost and looted. If they're being sent in and they're being lost and looted, you can't say that they're not going in. Yeah, they're getting lower and lower, but they're being attacked. So, yeah, they're going in, but they're being attacked as they go in. So, yeah, if I was a driver, I probably wouldn't want to drive into Gaza because I'd be being attacked as I'm going in and being looted. So let me keep reading. The aforementioned restrictions, together with cutting off electricity and reducing fuel supply, also has severe impact on the availability of water in Gaza and the ability of hospitals to provide medical care. The Chamber also noted that decisions allowing or increasing humanitarian assistance into Gaza were often conditional. They were not made to fulfill Israel's obligations under international humanitarian law or to ensure that civilian population in Gaza would be adequately supplied with goods in need. In fact, they were a response to a pressure of the international community, a request by the United States of America. All right, whatever. In any event, the increases in humanitarian assistance were not sufficient to improve the population's access to accessible goods. Furthermore, the Chamber found reasonable grounds to believe that no clear military need or other justification under international humanitarian law could be identified for the restrictions placed on access for humanitarian relief operations. Despite warnings and appeals made by inter alia, UN Security Council, UN Secretary General, states, and governmental and civil society organizations about the humanitarian situation in Gaza, only minimal humanitarian assistance was authorized. In this regard, the Chamber considered the prolonged period of deprivation in Mr. Netanyahu's statement connecting the halt in essential goods and humanitarian aid with the goals of war. The Chamber therefore found reasonable grounds to believe that Mr. Netanyahu and Mr. Gallant bear criminal responsibility for the war crime of starvation as a method of warfare. The Chamber found that there are reasonable grounds to believe that the lack of food, water, electricity, and fuel and specific medical supplies created conditions of life calculated to bring about the destruction of parts of the civilian population in Gaza, which resulted in the death of civilians, including children, due to malnutrition and dehydration, on the basis of materials present in the prosecution covering the period until 20 May 2024. The Chamber could not determine that all elements of the crime against humanity of extermination were met. However, the Chamber did find that there are reasonable grounds to believe that the crime against humanity of murder was committed in relation to these victims. In addition, by intentionally limiting or preventing medical supplies and medicine from getting into Gaza, in particular anesthetics and anesthesia machines, the two individuals who are also responsible for inflicting great suffering by means of inhumane acts on persons in need of treatment. Doctors were forced to operate on wounded persons and carry out amputations, including on children, without anesthetics, and were forced to use inadequate and unsafe means to sedate patients, causing these persons extreme pain and suffering. This amounts to crimes against humanity and other inhumane acts. The Chamber also found reasonable grounds to believe that the above aforementioned conduct deprived a significant portion of the civilian population in Gaza of their fundamental rights, including the rights of life and health, and that the population was targeted based on political and/or national grounds. Okay, so I'm going to stop there. It just said the Chamber found reasonable grounds to believe that the aforementioned conduct deprived a significant portion of the civilian population in Gaza of their fundamental rights, including the right to life and health, and that the population was targeted based on political and/or national grounds. Okay, let me see. I believe that the war started because Israel was attacked and because there are hostages, including hostages that are United States citizens being held in Gaza that haven't been released yet. I believe that there are people there that are parts of Hamas, and that Hamas teaches children that from real young age up to hate Israelis and to hate Westerners and to hate most of the world. So, yeah, do some research. Anyway, uh, it therefore found that the crime against humanity and of persecution was committed. Finally, the chamber assessed that there are reasonable grounds to believe that Netanyahu and Mr. Gallant bear criminal responsibility as civilian superiors for the war crime of intentionally directing attacks against civilian populations of Gaza. In this regard, the Chamber found that material provided by the prosecution only allowed it to make findings on two incidents that qualified as attacks that were intentionally directed upon civilians. Reasonable grounds to believe exist that Mr. Netanyahu and Mr. Gallant, despite having measures available to them to prevent or repress the commission of crimes to ensure the submittal of the matter of the competent authorities, failed to do so. On January 1st, 2015, the state of Palestine. I didn't realize Palestine was a state yet. I don't remember it becoming a state of Palestine yet. Okay, but it says on 1st January 2015, State of Palestine lodged a declaration under Article 12 of the Rome Statute accepting jurisdiction of the court since 13th June 2014. On 2nd January 2015, the State of Palestine acceded to the Rome Statute by depositing its instrument of accession with the UN Secretary General. The Rome Statute. First, I got to stop for a minute. Where's the state of Palestine? I tried looking on Google Earth and I still haven't found it. The Rome Statute entered into force the state of Palestine on 1st April 2015. On 22nd May 2018, pursuant to the Articles 13 and 14 of the Rome Statute, the State of Palestine referred to the prosecutor's situation since 13 June 2014 with no end date. On 3rd March 2021, the prosecutor announced the opening of the investigation into the situation of the State of Palestine. This following pretrial Chamber 1's decision on February 2021 that the court could exercise its criminal jurisdiction in the situation, and by majority that the territorial scope of this jurisdiction extends to Gaza and the West Bank, including East Jerusalem. On 17th November 2023, the Office of the Prosecutor received a further referral of the situation in the State of Palestine from South Africa, Bangladesh, Bolivia, Cameroon, Djibouti, and on 18th January 2024, the Republic of Chile, the United Mexican State, additionally submitted a referral to the prosecution with respect of the situation in the State of Palestine. So I want to look at something here, and we'll see all of the states that are part of the International Criminal Court. Which states are part of the International Criminal Court? These are all the states that are part of the International Criminal Court. As you can see, the United States is not one of them. Mali, New Zealand, Belgium, Côte d'Ivoire, Palestine. Capital is Jerusalem, huh? I didn't know that. Capital Jerusalem, Ramallah. Really? Since when? Okay, anyway. Armenia, France, Kiribati, Afghanistan, Argentina, Central African Republic, Luxembourg, Uganda, Australia, Honduras, Libya, Democratic Republic of, I believe that's the Congo, Bangladesh, Colombia, Nigeria, Andorra, Czech Republic, Jordan, Norway. So there's 124 countries, okay? You can see United States is not listed. United States is not on this list. So United States is not one of them. And the thing is there are 124 countries are the state parties to the Rome Statute of the International Criminal Court. Out of them, 33 are African states, 19 are Asia Pacific states, 19 are from Eastern Europe, 28 are from Latin America and Caribbean states, and 25 are from Western Europe and other states. Now, it was under the UN Treaty Rome Statute of the International Criminal Court, okay? And the statute was adopted on 17 July 1998 by the United Nations Diplomatic Conference of the Plenipotentiaries on the establishment of the International Criminal Court. Now, just so you know, Putin is also got charges on him, and Putin can't go around the world. He's gone one place so far where he was not arrested. He went to go visit another country, and they did not arrest him. I'm pretty sure that if Netanyahu were to come to the United States, we would not arrest him here, because the United States is good friends with Israel. But I'm not sure about whether he'd be able to go to other countries and what's going to happen. Um, I don't know. I've been watching all the wars that have been going on, and war is ugly. War is ugly. War is straight up ugly. And it would be nice if peace could come out of all of this ugliness and people could get along and put their differences aside and go play a friendly game of badminton and decide wars that way. But that's not going to happen, and we all know that. So, we all need to pray for peace. Anyways, that's the first time I've done a video like this. I hope that helps to answer some questions. Just thought I would go over this with you guys since I saw it posted. And anyways, you guys, I hope I'm not too opinionated. I have my opinions. I try to keep them to myself and try to stay unbiased. Anyways, you guys, I love you, and I hope you all have a great day. Much love, and God bless.